Okay, our third and final video presentation over this unit is dealing with the right of privacy, which we've been talking about in class. With the right of privacy now, probably the most difficult and the most controversial area in privacy is dealing with, of course, abortion. And this gets into very personal matters for a lot of people. You get a lot of people who are very headstrong one way and the other about this issue, about whether or not it's uh, murder on the one side, and or on the other side, it's the right of the woman to choose how she wants to do with her body as she so freely chooses. It gets into a very controversial aspect. Roe versus Wade basically was a Supreme Court case that set this privacy matter when it came to women. It's a 1973 Supreme Court case. What it did is the Supreme Court struck down a Texas law that made abortion a crime, except when necessary to save the life of the mother. Even in cases of rape in the state of Texas, you could not get an abortion in 1973. Well, how this whole thing came about is because of a woman named Norma McCorvey. She got pregnant. She had already had a child previous to this that she could not take care of and had given it to her mother to raise. She got pregnant again. The father left, had nothing to do with her, nothing to do with the baby, so she tried to claim rape. However, there was no police report showing that she was raped, but it didn't matter anyway. If she would have been, she could not have gotten an abortion anyway. So, two attorneys, Sarah Weddington and Linda Coffey, decide to represent Norma in her quest to try to seek the permission to have an abortion. This was before 1973 is when this took place. This was in 1971, actually. So 2 years is going to go by. Well, of course, you can already figure out the math. Norma McCarvey never did get to have the abortion. She had to have the baby. She gave it up for adoption, and basically after the case came about and after it was said and done, years later, she actually went the other way on her stance on abortion and is actually very negative and very anti-abortion now. But at the time, she was wanting to be able to get permission to have it. The claim by the attorneys Weddington and Coffey was that this was a 14th Amendment matter of the right to privacy, which they said encompasses a woman's decision whether or not to terminate her pregnancy. The whole idea on the side of the right to abortion side is that that fetus is not a living, breathing human yet because it cannot live and breathe on its own. So therefore, it is part of the mother. If the mother so chooses to terminate that pregnancy, she has the right to do so. That's what their argument was under the 14th Amendment. So this case goes to court. It was a very long, drawn out case. The Supreme Court's ruling came back, and basically they ruled in favor of a woman's right to seek an abortion. They did, however, put limitations on that right. Basically, what the Supreme Court ruling said is that during the first trimester of a woman's pregnancy, which is weeks 1 to week 12, a woman's right to an abortion cannot be interfered with medical judgments in the matter. So basically, from week 1 to week 12, a woman has a right to seek an abortion. The problem is being able to find a place to do the abortions. Here in Garden City, for example, you can't go over to the women's clinic or go over to the hospital and say, I want to have an abortion, because those are private institutions. They are religious institutions. Catholic hospital, they do not have to perform the abortion, nor would they. So in Kansas, there's really a very limitation of where you could go to get an abortion. There used to be a clinic in Wichita, but that got shut down after the doctor was assassinated by an anti-abortionist. So now you would have to go to Kansas City to seek that. Well, that takes a lot of money and time for people, especially for women who are pregnant, and many of these are young women that cannot afford to go stay in a hotel and to do that in order to have the abortion. So even though you have that right, there is other limitations being put upon that. Now, during the second trimester, weeks 13 to 24, the state, acting in the interest of the woman, can make reasonable regulations about how, when, and where abortions can be performed, but they cannot prohibit it. That is important here. Cannot prohibit the abortion still from taking place during this week here. So second trimester, a woman still has the legal right to seek the abortion, but they can put limitations. And the anti-abortion groups have been very powerful at putting these limitations down, making a woman wait 24 hours to be able to get the abortion. In some states, requiring them to have an ultrasound. In other states, having them required to take counseling before seeking the abortion. So they try to do everything they can to make the woman feel guilty, make the woman feel that she's committing some type of a murderous event, whatever they can to try to stop the abortion from taking place. But they still cannot stop the actual abortion if the woman wants it. Now, the third trimester is where the Supreme Court has said that the states can stop the abortion, and that is because, notice the difference, state acting in interest of woman is during the second trimester. Third trimester, it's the state acting for the protection of the unborn child now. That's a huge difference. Now they can prohibit all abortions except when it's necessary to preserve the health of the mother. Then the abortion can still be performed during week 25 to term of the pregnancy then. These are called late-term abortions. Very few abortions are done during the third trimester. Most of the time, it's only in the preservation of the life of the mother because of some medical matter. That is less than 1% of all abortions performed in the United States are done during the third trimester. Biggest majority of the abortions are performed either during the late first trimester or very early second trimester. Weeks 12 to 13 is when you see a majority. Here on this chart, you can kind of see the progression of what a fetus looks like as it develops and grows. And you can see from an embryo at 8 weeks, okay, and that would be during the first trimester here. And then the fetus at 12 weeks, that would be the end of the first trimester. At the end of the 16th week, that would be in the midterm of the second trimester. Here's the fetus at the 24th, and you can kind of see the change. You can kind of see the change that's taking place here. And then it gets into the more development. And of course, after the 25th week, which is right about in here, that is where they can ban the abortion from taking place then. Other court cases that's come about since Roe versus Wade that has major changes on abortions has been such, for example, Webster versus Reproduction Health Services. This prohibits all abortions except for the preservation of the life of the mother or health of the mother. They also can, under this court case, the Supreme Court did give the ruling that public hospitals or clinics do not have to perform abortions if they so do not want to. If a mother is 20 or more weeks pregnant and the tests show that the fetus is viable, which means that the fetus can live on its own without interruption, then they can go ahead and ban the abortion as well. The last part here of this court case was parent notification, and that is required in most states unless a judge gives permission. Previous to this court case, a child under the age of 18 could have gotten an abortion without parent notification, without the parents even knowing that she was pregnant. Now, virtually all states mandate that the parents of a child under the age of 18 must be notified unless there is extenuating circumstances such as incest or something to that effect, that the judge then can give permission for the abortion if so requested. Planned Parenthood versus Casey is another important court case that came out of dealing with abortion. That is where states may place a reasonable limitation on a woman's right when it comes to the restrictions cannot impose an undue burden. But here are some of the things that the Planned Parenthood versus Casey did say, is that a woman can seek an abortion must be given professional counseling before she gets the abortion. She must wait at least 24 hours before she can have it. So she has to go to the clinic, be checked over, and then she has to wait another day in order for her to perform the abortion. The reason why the anti-abortion groups wanted this is to allow for more time to make the person maybe go against their thoughts and not have the abortion. Again, unmarried females under the age of 18 must have consent. And doctors and clinics must keep detailed records of all abortions. And again, basically the purpose here is to try to make it more difficult for doctors and clinics to be able to have their abortion clinics stay open. And they do a lot of things to try to ban and try to limit this. Texas and Kansas have some of the most stringent laws on abortion in the United States. A lot of anti-abortion groups, of course, are in these conservative states, and they tried more and more to try to ban and try to get rid of abortion. All right, finally, is dealing with those late-term abortions, what's known as partial birth abortions. In 2000, there was another Supreme Court case, Stenberg versus Carhart, in which the court tried to apply a rule of what's known as the undue burden rule. Nebraska tried to pass a law which prohibited the procedure of a partial birth abortion. This procedure would be done out to 16th week, and you can kind of see the procedure here that takes place with it on this chart. But basically, what the courts tried to do, I'm sorry, what the anti-abortion groups tried to do is they tried to get laws passed that basically would ban any type of late-term abortion that would be done, even in the case of the health of the mother. It didn't allow for the exception to protect the life of the mother. So basically, it is banning all abortions after the 16th week. The Supreme Court came back and said, no, you can't do that. The court basically ruled that this law to try to ban it was unconstitutional. And so still today, the Supreme Court has made it pretty clear that when it comes to late-term abortions, they can be banned, but you cannot ban it in terms of the life of the mother. If the mother's life is in jeopardy, then late-term abortions can still be performed then. We're going to talk a little bit more about some of the more current cases dealing with abortion in class, but at this point, that's the end of the presentation.